Well, good morning, everyone, and welcome to the Wilson Center. My name is Will Pomerantz. I'm Deputy Director of the Kennan Institute, as well as head of the Wilson Center's Rule of Law Initiative, and I'd like to welcome all of you to today's event and to the Wilson Center, which serves as the living memorial to our 28th president. Today's program is on protecting civil liberties and the rule of law in the age of terrorism. Terrorism has already revealed itself to be the scourge of the early 21st century, starting with 9/11 and through the March 2016 bombings in Brussels. Terrorist assaults not only threaten a country's sense of security, but also its underlying values and principles. The fight against terrorism is not only about security, it can also undermine democratic values of open societies or be exploited by more authoritarian regimes to discredit, if not repress, political opponents. The Wilson Center is pleased to host today's conference that addresses both U.S. and international responses to the threat of to the security threat posed by terrorism. By understanding how other countries respond to and potentially abuse the threat of terrorism, this conference will put the U.S. debate on national security in a global and comparative perspective. The conference will further clarify the challenges that confront the next administration and how to prevent the debate over terrorism from being appropriated by authoritarian regimes. Now, there are many people I need to thank for making today's event possible. I want to thank the staff here at the Kennan Institute, particularly Madison Brady and Joe Dressen, for helping to organize today's event. I also want to highlight that today's event is part of the Wilson Center's Rule of Law Initiative, which seeks to address global legal issues on a regional and a comparative basis, thereby using all the expertise here at the Wilson Center. And this is just one of many programs that we conduct that are associated with the Rule of Law Initiative. But my biggest thanks, of course, go to the Henry M. Jackson Foundation for sponsoring today's event. We are so pleased to be working with the foundation and who has supported so many of the Kennan Institute's programs in the past. It's been a great collaboration, very fruitful, and we are so pleased to continue it on today's event. And now I would like to invite John Hempelman, the president of the Henry M. Jackson Foundation, for a few opening remarks as well. John.
Well, good morning, everyone. On behalf of the Henry M. Jackson Foundation, welcome to this really interesting discussion on a very challenging yet very, very important subject. The foundation was established in 1983 to continue the work to advance the legacy of Scoop Jackson, who you may know was a U.S. Senator from Washington State for many years, a presidential candidate, but a leading expert in his time on particularly issues like national security and the rule of law. I'm struck by the fact Will and myself and our vice president of the foundation, Craig Gannett, three of us are lawyers. Scoop was a lawyer. We grow up and we are trained to love the law and to advance it and have it be the center of our lives and a core issue in democratic societies. And so when this issue that we're going to be discussing today, whether it's in the United States or it's in Europe or it's in North Africa or wherever, where there's this conflict between national security and the rule of law and civil liberties, it's particularly, shall I say, a severe issue for those of us like Will and Craig and I, and I'm sure others in the audience, I know Professor Kahn, who grow up and are trained to love the law and see it as a core value in our society. So that's the subject that we're going to be talking about today. I want to echo what Will said. Laura Eglitzen, who will moderate the next panel, who is our executive director, and I were saying how comfortable it is to be here at the Wilson Center and working with the Kennan Institute, because we have a long history of collaboration between the foundation and the Kennan Institute. So with that, let's go on with the program, and the first panel is going to be moderated by Laura Eglitzen, who is our executive director of the Henry M. Jackson Foundation.
quiet room. I have your attention. That's great. Well, good morning, everyone, and I'd like to add my welcome to our panel. As John indicated, we do have a lot of legal firepower actually on this panel, so it's a pretty impressive group, and we are delighted to be working together in partnership with the Kennan Institute for, I think it must be at least 15 years now. So thanks to Will and to Joe and to Madison and to everyone else that plays a role with us here. So we wanted to ground today's discussion, as Will indicated. This day is really about both the global and domestic challenges around this issue. And today we wanted to begin with this panel kind of grounding us on some of the intractable issues that have been facing our country, going back to Guantanamo and all the other issues of technology and privacy that we're seeing in the paper, issues around the no-fly zone, and then issues that even relate to cross-border tensions around some of the privacy and terrorism concerns. And so we wanted to have this panel kind of reflect on some of the U.S. Context and concerns and the role that the U.S. is playing, how well it's doing, whether it can be doing better, and to what extent it's doing better maybe than some of its international allies or worse. So I think we're going to go in the order on the conference and begin with Jennifer Daskal. She will help us think about some of the issues around the legacy of Guantanamo, and I think also dealing with some of the border enforcement issues. Jennifer is an associate professor of law at the Washington College of Law at American University and has a very distinguished record in teaching and counterterrorism, and also with the Department of Justice and Human Rights Watch. So we're delighted that Jennifer can lead us off on our panel today. And I urge you all of our panelists, to look at the bios in the packet for a little bit more extensive background. So Jen.
Great, thank you. And thanks to the Wilson Center and the Henry M. Jackson Foundation for putting on such a great event, and to Will Pomerantz for inviting me to participate. So I'm going to use my time to talk about two seemingly disjointed issues, but I will do my best to connect them: Guantanamo and law enforcement access to data, and you can tell me at the end whether or not I've done my job. So first, let's start by talking about Guantanamo. As probably everyone here knows, Guantanamo was started back in 2000. The first detainees were brought to Guantanamo in January of 2002. It stemmed, the desire to create this detention base stemmed from then President George W. Bush's desire to place detainees outside the rule of law. They believed that by placing detainees at Guantanamo outside the U.S. territory, they would not be subject to constitutional rules. And they also categorized the detainees at the time as outside the protections of international humanitarian law, outside of the protections of the Geneva Conventions, because they conceived as the conflict with Al-Qaeda, a transnational terrorist group, as neither an international conflict nor a non-international conflict, and therefore not covered by the then applicable rules of international law. The detainees were not given prisoner of war protections, and they were deemed not even protected by what's known as Common Article 3 of the Geneva Conventions, which provides very baseline humane treatment protection requirements. As probably everyone here knows, the Supreme Court eventually disagreed with both of these aspects of the Bush administration's legal analysis. In the case of Hamdan versus Rumsfeld, which is probably most well known from striking down the military commissions, the military tribunals that were then in place at Guantanamo. In my view, actually the more important part about that case, about the Hamdan versus Rumsfeld case, is the decision by the Supreme Court that in fact the conflict with Al-Qaeda, the conflict with transnational terrorist groups, transnational non-state actors, is in fact a non-international armed conflict that's covered by the Geneva Conventions, and therefore Common Article 3, which I mentioned earlier, which ensures baseline humane treatment requirements, kicks in. This was important. It led to President Bush finally acknowledging the existence of unacknowledged prisoners, of black sites, and transferring the handful of prisoners that were still held in CIA custody into Guantanamo. Then in 2006, in the case of Boumediene versus Bush, the Supreme Court made clear that, at least in some cases, the Constitution does in fact apply to Guantanamo. In this case, the court held that the suspension clause and that applied, and that therefore Guantanamo detainees had habeas rights. And this led to numerous habeas challenges by the detainees. Over the course of all of this, and as Guantanamo was in the spotlight, I think it became increasingly clear to commentators, to politicians, to people across the political spectrum that Guantanamo was really becoming a black spot on America's reputation. And it's kind of hard to remember now, but in the 2008 elections, both presidential candidates of both of the major political parties, Barack Obama and John McCain, supported the closure of Guantanamo. And even George W. Bush pushed his administration to try and close it before they eventually decided it was just too hard to do. So just a quick snapshot of where we are with Guantanamo right now. At its peak, there were close to 800 detainees there. By the time Obama took office in January of 2009, the numbers were down to 242. As everyone knows, President Obama very loudly and publicly announced his decision that he would close Guantanamo within a year. That obviously didn't happen. But the number is down to 61 detainees, about half of which are Yemeni detainees. Of those 61, there's 3 that are serving sentences. There are 7 that are pending military commission trials, including the 5 individuals that were deemed responsible for the 9/11 attacks. There are 20 that have been cleared by what are known as periodic review boards. They're boards of all heads of all of the security and intelligence agencies of the U.S. government that review the files of the detainees and make a determination as to whether or not they continue to pose the kind of danger that justifies continued detention. 20 individuals who are still there have been cleared for transfer. These are individuals that presumably the Obama administration is working on transfer agreements, trying to find places to send them to. There's 19 that have been deemed required for continued detention by these periodic review boards based on a determination that they pose that continued detention is, quote, necessary to protect against a significant threat to the security of the United States. And there are 12 that are awaiting a determination by the periodic review board. So at the end of the day, of this population of close to 800 detainees, we're left with about 19 to 31, depending on what happens with these remaining periodic review board determinations, that can't be transferred according to these determinations. Now, I think there's important questions to be asked about how long can these detainees be held, what would need to change to determine that they no longer pose a threat as they age, as they become increasingly disconnected from the groups that they were a part of, and how much we should really fear 24 plus men who have been out of circulation from the groups that they were part of for well over a decade, particularly when we think about how many hundreds of thousands of individuals around the world really do continue to pose us a threat and wish us harm. And we also should consider the fact that if these detainees hadn't been moved to Guantanamo, if they had been held in Iraq or Afghanistan like many other detainees, they would have been transferred to the Iraqi authorities or the Afghan authorities long ago and probably either be held in their prisons or most likely be transferred out. But putting that aside, we need to figure out what to do with these 19 to 31 detainees. Donald Trump has said that he would likely populate Guantanamo further. Hillary Clinton, on the other hand, has long supported closing Guantanamo. She really pushed for it while she was in the administration. And like President Obama, she would presumably commit not to bring additional detainees there. Now, as is probably clear, I think it would be a huge mistake to bring additional detainees to Guantanamo. It's a mistake that shouldn't be repeated. There's a reason why ISIS dresses its prisoners in Guantanamo garb before it executes them. And there are a range of other tools at our disposal, including cooperation with foreign governments, including the very successful use of federal court prosecutions that have been used in ways to incapacitate individuals and that have much more finality and much more certainty than the detentions at Guantanamo, which continue to be surrounded in at least some controversy. But let's turn to the closure debate. The key, as I said, is those 19 to 31 individuals. And many, many people across the political spectrum think that the way to deal with those detainees is to bring them to the United States, to close Guantanamo, and to outfit a detention center in the United States. Thompson, Illinois was talked about at one point. There's been other facilities that have been talked about as well, to bring these detainees to the United States and put them in continued law of war detention here in a facility run by the Department of Defense. I want to say that with respect to the uncharged detainees, I think that is a huge, huge mistake. It's a Pyrrhic victory and one with many more long-term negative consequences, in my view, than keeping those remaining detainees at Guantanamo until and when we find a solution for them. I think it's fine and actually quite preferable to bring those detainees who have been tried, who are serving sentences, or who are going to be facing trial to the United States. There's all kinds of advantages to holding those trials there in terms of ease of access to lawyers and facilitating individuals who are interested in the case being able to watch the case. But if we open a detention center here for detainees who are uncharged, who are serving who are continued to be detained pursuant to the laws of war for an indefinite amount of time, even for those 19 to 31 detainees, I think it will be incredibly tempting for any executive official to populate that detention center further. It's easier in the short term than bringing criminal charges, although, as I've said, I think in the long term it creates more problems than it solves. And you will, in my view, inevitably see this detention center, this facility, this idea of detention without charge on U.S. soil grow, take root, become part of what we do in America, where we have never, outside of a few examples that I think most of us don't feel good about in our history, do as Americans. I think we're going to hear later Jeff talk about the no-fly list, and I'll just end my discussion about Guantanamo with this. If you build it, they will come. All right, so I don't know how much time I have left, but I want to use my last few minutes to talk about law enforcement access to data, and here's my attempt to connect these two issues. So if I'm going to say that we should use our criminal law systems to handle terrorists that otherwise might be sent to law of war detention or elsewhere, we need to make sure that we have the tools to be able to do so. And there are two big problems right now with respect to law enforcement access to data. One is U.S. ability to access data that happens to be held overseas, and the other is restrictions on foreign governments being able to access data that happens to be held in the United States, which impedes foreign governments' ability to successfully prosecute and handle terrorists as well as any other ordinary crime. So very briefly, how am I doing?
You're fine.
Okay, very briefly, there was a Second Circuit case that came out in June, it's widely known as the Microsoft Ireland case. And in that case, the Second Circuit said that if the U.S. law enforcement gets a warrant based on probable cause for the data, in that case they served the warrant on Microsoft. Microsoft said that you can't actually access this data because this data is held in Dublin, Ireland, not in the United States. Our U.S. warrants only have territorial reach, they don't have extraterritorial reach. Microsoft eventually won in the Second Circuit, and so the rule now is that if the U.S. gets a warrant based on probable cause and serves it on a company, those companies can only turn over data that happens to be held in the United States at the moment that the warrant was served. And in order to get access to data that's held overseas, they need to make what's known as a mutual legal assistance request to the foreign government and ask the foreign government to access that data pursuant to its processes and then ultimately turn that data back over to the United States. There's a number of problems with this. First, it's very time-consuming and laborious. It takes months, sometimes much longer, for foreign governments to respond to these requests for data. Second, in some cases, there is no foreign government to even make the request to. This is particularly true for certain companies. So Google, for example, has organized itself so only US-based employees can access and retrieve the data. If Google gets served a warrant and determines that at the time that that warrant is served, the data happens to be overseas, under the Second Circuit ruling, they can't turn over that data lawfully. On the other hand, there is no foreign government for the US to make a request to, because the employees who can access the data are US-based, and those foreign governments don't have jurisdiction over the individuals who can access the data. That's a problem from my view. And then the third thing I want to say about this case is it's been described by many, many as a privacy win, that by limiting law enforcement access to data that happens to be in the United States, that's somehow going to enhance privacy. I also think that's a huge mistake for a couple of reasons. First, most importantly, the US standard of a warrant based on a probable cause is one of the highest, the most privacy protective standards that exists around the world for accessing data. And secondly, if you require US law enforcement to use processes overseas, as the flip side of that same point, those processes generally often have less protections for privacy than would apply if you're requiring US law enforcement to get a warrant based on probable cause. So I think it's a mistake to think this is a privacy win, and I think it's causing huge problems for law enforcement, and it needs to be fixed. There is a flip side of the problem, which I'm happy to I hope we have time to talk about during the question and answer period, and I believe Robin may raise this as well, and this is foreign governments accessing data that happens to be held in the United States. There's a blocking provision in US law that prohibits companies from turning over data directly to foreign governments. This means that foreign governments that want access to data that happens to be US held also have to make a mutual legal assistance request for that data. It's a long, laborious process. It takes the US government an average of 10 months to respond. Foreign governments are also increasingly frustrated. They're responding in a number of concerning ways, like mandating data localization, like unilaterally asserting jurisdiction, which puts companies in this bind between two conflicting laws. And it's not just a theoretical problem. There was a Microsoft employee in Brazil who was arrested in January of 2015 for failure to turn over data that Brazilian authorities sought that US law prohibited him from turning over. He was arrested in Brazil. And then finally, we're starting to see, and I think we will increasingly see, foreign governments seeking out surreptitious, less transparent ways of getting access to data. And that has negative consequences for both our privacy and also for the security of the internet. So I will stop there, but I hope we can talk about that issue more as we go on.
Yes. Thank you, Jennifer. That's a good start to have us see both a historical perspective on Gitmo and the beginnings of our discussion, which I think Robin will continue. So Robin Green from the Open Technology Institute at the New America Foundation specializes in these very issues of surveillance and cybersecurity, and has been researching and developing policies to protect individuals' privacy, securing the internet, and fueling the development of and access to emerging technology. So I think this is a good lead on, Robin, to your work.
Thank you. And I just want to echo Jennifer's thanks to everyone for putting this wonderful conference on and for inviting me to speak. And thank you all for coming. Today's event really could not be more timely, especially if you read the headlines. As a tech advocate, I'm very pleased to be able to speak about how to balance privacy and civil liberties, but also being an ironically analog girl in a digital world, I actually want to kickstart this little presentation with a clip from my favorite show, and a show from the 90s, The West Wing. So I think it's going to auto-play. Oop, actually, hold on. Let me set the stage for this.
You don't think the guy that called Sam would know how to call a senator's office?
Mr. President, if this is really about abortion, he already
stop
told
that?
us.
Sorry.
About abortion. It's about the next 20 years. 20s and 30s, it was the role of government.
I jumped ahead of myself. You can see I'm literally analog. So Ultimately, this clip is about President Bartlett trying to select a new Supreme Court justice. He thinks he's landed on the guy, but one of his advisors, Sam, has uncovered a law review article that this would-be nominee wrote, arguing that there's no guarantee of privacy in the Fourth Amendment. So what you're about to see is Sam arguing why this is entirely disqualifying. And now, thank you.
You don't think the guy that called Sam would know how to call a senator's office?
Mr. President, if this is really about abortion, he already
It's not
told
just
us.
about abortion. It's about the next 20 years. 20s and 30s, it was the role of government. 50s and 60s, it was civil rights. The next 2 decades are going to be privacy. I'm talking about the internet. I'm talking about cell phones. I'm talking about health records and who's gay and who's not. And moreover, in a country born on the will to be free, what could be more fundamental than this?
So this episode actually aired in 1999. At that point, mass consumption of the internet had only just begun. My memories of that time still screeches with the sound of the modem. Amazon was a moonshot as a business model. This is a time that is technologically very far away from where we are today, yet he's talking about the next 20 years. We're smack dab in the middle of those 20 years. Yet with all of the innovations that have happened in the last 17 years, our government has not done a very good job of keeping pace with new laws and policies that are needed to protect our privacy, considering how the world has changed. So we saw one of the best examples of how we have not had our government keep pace 3 years ago with the Snowden revelations that rocked the public. They uncovered a scale of surveillance that privacy advocates had long warned of, but that most people really didn't believe would be possible because they seem so anathema to our Constitution and our democratic values. They were also shocking because they revealed the extent to which government went to hide the scale of surveillance, to really obscure the reality of what was going on. The president, the intelligence community, and Congress responded to these revelations by, for the most part, embracing reforms to surveillance laws and policies. But they still haven't grappled with the problems of mass surveillance, especially under programs like Section 702 of the Foreign Intelligence Surveillance Act, FISA, and Executive Order 12333. And there has been a backslide in the last 2 years. Privacy advocates are again firing on all cylinders to push back against dangerous new surveillance proposals. And again, we in the public are shocked by new revelations about the government interpreting laws in ways that we really never would have expected. The U.S. can and should be a world leader on protecting privacy and civil liberties, but unfortunately right now our country is failing to live up to that potential, and we are moving in the wrong direction. So what do I mean by that? I want to talk about a few examples. First, the FBI has started to push Congress to pass a significant expansion of the National Security Letter Authority. FBI Director Comey has even called the surveillance expansion his top legislative priority. NSLs are similar to administrative subpoenas. The FBI issues them to companies and institutions like libraries seeking certain information about those institutions' users, and there's no judicial oversight for the FBI's use of national security letters. The FBI simply self-certifies that it's met the standard and then issues the NSL to the company or institution along with a non-disclosure order or a gag order so that that recipient can't tell their user that they've received the demand. In fact, the user will not have really any opportunity for judicial redress in the event that the NSL has been issued in an abusive or overbroad manner. The only way a court would ever really find out about the NSL is if the recipient chooses to go through the lengthy and costly process of challenging the NSL or the gag order that accompanies it in court. In the years after the Patriot Act, there was a lack of judicial oversight that wound up leading to massive abuses of the NSL authorities, including the use of NSLs as a tool for bulk collection. In fact, in 2004, FBI agents issued 9 NSLs that forced companies to hand over the information of 11,000 customers. And that is only 9 of the almost 57,000 NSLs that were issued that year. The USA Freedom Act did pass last year, and it now prohibits using NSLs for bulk collection. But the problem is it didn't address other continued FBI abuses with this authority. For that reason, privacy advocates are very concerned about expanding NSLs to include something called electronic communications transactional records, ECTRs, which is what the director of the FBI has proposed. So, sorry, this is not going now. So just briefly, this is what the National Security Letter Authority authorizes.
You don't think the guy that called Sam would know how to call a senator's office?
This is what I get for trying to use PowerPoint, you know? Sorry, guys. Teaches me my lesson. So yeah, this is basically what the NSL authority authorizes you to request. There are two separate sections. I'm only referencing the first section because they're more or less identical. But as you can see in bold are the types of records that you're supposed to be able to access. This is what electronic communications transactional records can reveal. As you can see, it's extremely revealing. They're metadata about all of our online communications. Some people have referred to them as digital fingerprints, but they're actually much more than that because they do more than just reveal your identity. They're really more like digital DNA mapping for everything you do and say online. They reveal information like who you communicate with, whether it's through chat, text, whether it's through video. They reveal what websites you visit, what kinds of accounts that you have, what services you use, and where you sign on from those accounts, what time, and much more. The FBI actually is able to use these kinds of records to develop very detailed pictures, profiles, if you will, of someone's habits and interests, their political beliefs, their religion, really personal details about someone's life. And in some ways, they're much more revealing than the actual content of what someone does or says online. The FBI has issued NSLs that include demands for ECTRs since the early 2000s, but in the last 8 months, the Bush administration, 8 years ago, Justice Department lawyers concluded that the NSL statute didn't authorize the FBI to demand ECTRs as part of its NSL demands. We've recently learned that the FBI has really just disregarded DOJ's advice and continued to demand ECTRs in their NSLs. This is an example of a 2013 NSL that Yahoo received, where they actually include this very helpful list of all of the different types of electronic communications transactional records that are revealed. And as you can see, they go far outside the scope of just information like the name, billing address, subscriber information that you're authorized to access. It includes things like URL information, which is your web browsing history, internet protocol address information, which can reveal your geolocation information, the resources and different services that you're subscribed to. This is very detailed and personal information, and it's very clearly far outside of the scope of what the law allows. So a lot of people think, well, you know, it's not wrong to ask, right? What can it hurt to ask? But that's wrong. Since 2008, some companies have refused to give over this information without a court ordering them to. And that's really good, right? Because that protects Americans' privacy in a really important way. But the problem is not all companies are going to have the resources or just the sophistication to know that they're not necessarily legally obligated to hand over this information about their customers. And that's a real problem, especially because as our nation's top law enforcers, it's really not too much to ask the FBI to strictly abide by the law themselves. And right now, the FBI can still access electronic communications transactional records. They issue compulsory demands for ECTRs under its Section 215 authority of the business, which is the business records provision of the Patriot Act. This was also amended by the USA Freedom Act. Importantly, the standard for issuing an NSL and a 215 order are identical. The target of the order merely has to be relevant to an authorized investigation for counterintelligence or counterterrorism. The only difference is that for a 215 order, the court has to certify that the standard has been met, whereas for an NSL, the FBI self-certifies that the standard has been met. Last year alone, the FBI issued 13,000 NSLs for information about approximately 50,000 people. This is not a seldom used authority. Considering its checkered history and the lack of judicial oversight, really expanding this authority to include actors isn't just going to open the door to abuse, it's going to virtually guarantee it. And the Senate came dangerously close to passing the surveillance expansion last year. So this is really a prime example of where our country is going in the wrong direction in terms of balancing privacy and national security. One other example is the Yahoo case. Reuters recently broke a story about a surveillance order that Yahoo received in 2015. The short story is that Yahoo received some sort of classified demand that required it to scan every single one of its users' incoming emails in real time for a set of characters. This could have been something like an email or other specific identifier, like a phone number, a phrase in an email or an attachment, or something like a malware signature. While the government hasn't confirmed this, reporting strongly suggests that the order was issued under Title I of FISA, which allows the government to wiretap an American in a foreign intelligence investigation if they have probable cause to believe that the American is working for a foreign power. This appears to be the first instance of government-issued demand for real-time surveillance of every user of an internet company, or at least the first that we know of. And despite this, Yahoo didn't challenge the order, and to comply with it, they had to write their own spyware and apply it to their system. Now, there are a lot of security concerns with how Yahoo chose to go about complying with the order and implementing the surveillance software on their system, but the biggest concerns really have to do with the government. So one concern is that this surveillance order significantly exceeds what a plain reading of the law allows. Title I authorizes targeted surveillance. An email service provider who boasts over 500 million users being ordered to scan every one of its emails, incoming emails, is the opposite of targeted. It's mass surveillance. It's a violation of the Fourth Amendment. So again, the government, less than 2 years after the Snowden leaks, is back to stretching interpretations of the law so far that they shock the public when they come to light. And this brings me to my second concern. This is yet another transparency failure. There's no reason why the public should be learning about this legal interpretation through an unauthorized leak as opposed to through a good faith disclosure from the government. Congress and voters have the right to know how the government is interpreting the laws it applies, and that's especially the case when those interpretations might, or I would argue in this case clearly, exceed what the law provides on its face. We've already seen excessive government secrecy around surveillance do incalculable harms to U.S. companies in the wake of the Snowden revelations. To be a world leader, our government must finally come to terms with the fact that while secret investigations are okay, secret laws are not. The last concern that I have focuses on the fact that in order to comply with the order, Yahoo had to write and implement the spyware on its own system. So the surveillance order essentially coerced Yahoo into becoming an arm of the government. This is deeply troubling because wiretap assistance provisions of criminal and foreign intelligence surveillance laws don't go so far as to require companies to build surveillance systems for the government. Yet that's exactly what Yahoo did. And it's also very similar to what the FBI demanded of Apple when it took Apple to court last year to hack into the San Bernardino shooter's iPhone to bypass the encryption. So this leads me rather seamlessly to my last example of an area where the US should be a leader, but is failing at balancing privacy with national security. So this is the debates around encryption and government hacking. Encryption is absolutely essential to data security. It's essential to national security, to the economy, and to privacy. It's literally the key upon which we all depend to be able to shop in stores using our credit cards or online securely, to keep private our communications, whether they're top secret communications between government officials or just everyday gossip. It's also essential to, protecting the innovations and the intellectual property of American businesses. And it protects our financial records and our health records, and I could really go on forever about the benefits of encryption. I'm sure you all have heard it before. But for more than 2 years, in spite of all of the benefits of encryption, the director of the FBI has been pushing for a solution to the, quote, encryption problem, where law enforcement can't access some subset of data that it's seeking during an investigation because it's protected either by device encryption or by end-to-end encryption. And so he's called for some sort of an encryption backdoor mandate where companies would have to guarantee access to encrypted communications or data on their devices or services. If he was here right now, I'll be the first to say he'd probably dispute my characterization of this. He would probably argue that he's been calling for a debate and not for an encryption backdoor mandate. But the thing is, we've had a debate, a long debate, and he just isn't happy with the answer. So since Director Comey began this campaign, the problem has been considered at length by cryptographers, by advocates, and by academics. Countless panels, briefings, and events have been hosted by all sides of this debate. Congress has held numerous hearings, and several research papers have been written. The Office of the Director of National Intelligence even organized a workshop of leading experts convened by the National Academies of Sciences. All have assessed whether one can establish secure third-party access to encrypted communications or data. And by that, I mean ensuring that if the right guys can get in, that the wrong guys can't get in. That by creating, exceptional access for law enforcement, you're not also unintentionally creating a way for a malicious hacker to access those communications. The conclusion of all of this debate has been virtually unanimous. There is no way to securely establish third-party access to encrypted communications. And as renowned cryptographer Matt Blaze warned the National Academies workshop, the risks of mandating backdoors to our encrypted communications or devices would be, as I have up here, unbounded and unpredictable. What he means by that is there's literally no way that we can even anticipate how insecure our systems and our data would become if we were to mandate encryption backdoors. At that same workshop, my boss and director of New America's Open Technology Institute, Kevin Bankston, I think put it best when he suggested that the United States can either invest hundreds of millions of dollars to update law enforcement's investigative capabilities for the 21st century, or the economy can face a loss of billions of dollars if exceptional access is mandated for US products. In other words, we should not be debating whether or not to mandate encryption backdoors. We should be considering what an appropriate, rights-respecting legal framework entails for government hacking into devices or networks to further its investigations. For 20 years, the FBI has been hacking without any explicit rules or protections like the ones that we put in place for wiretaps, even though hacking is more dangerous from a security perspective and more invasive from a privacy perspective. Congress has never held a single hearing on these tactics, and they are, in fact, set to expand on December 1st when the federal rules of criminal procedure changes go into effect. Instead, we've spent the last few years rehashing a debate about encryption backdoors that was decided decades ago when Matt Blaze showed conclusively during the crypto wars of the 1990s that there is no way to establish a secure backdoor. Unfortunately, countries around the world have followed Director Comey's lead. China, France, the UK, Kazakhstan, and other countries have either considered or implemented proposals to mandate encryption backdoors. It's incumbent upon us as a nation to lead in the right direction, where our policies respect and protect privacy and civil liberties, and where we would be proud and not concerned if they were to be mirrored by any country around the world, no matter their record on human rights. And right now, with regards to surveillance and encryption policies, I do fear that we're going in the wrong direction. Thank you.
Thank you, Robin. Well, Jeffrey Kahn is certainly well equipped to give us a broader perspective on this. He is a professor of law at Southern Methodist University and teaches and writes on American constitutional law, but also has a broader perspective on human rights and is an expert on Russian law and counterterrorism. And today I think he's primarily going to speak about the right to travel, but it will be interesting within the perspective of your international viewpoint as well. So, Jeffrey.
Well, thank you very much, Laura, and thank you, Jen and Robin, for providing so much context and important information about all the data that is collected and the restrictions and exceptions to that data. And now I want to talk about what we use that data for. And I want to thank the Kennan Institute and the Wilson Center and the Jackson Foundation for having us here. This is an important dialogue. And I want to apologize for the froggy sound to my voice. I blame it on my 178 students and 2 daughters back in Texas, but I will not blame it on the microphone, as has become fashionable lately. But I'll do the best I can. There are 2 questions that interest me in my research on all of this data collection and what we do with it. And the first question is, how do states restrict free movement of people who are under suspicion? And the second one is, what stops the United States in particular, but any other state, from using those same techniques to restrict other rights? And let me give you my answers up front, and then I want to discuss a few of the implications of the American approach and where I think it's going. The answer to the first question, how do states restrict free movement? How does the United States do it? Well, we use terrorist watch lists. And we have to be really careful about this word, watch list. A watch list used to mean a list of people who were literally people worth watching. But now, what we do with this watch list is not traditionally what we did with watch lists. What we have is an action list. And using an old term for new behavior blurs a really important historic and legal boundary, a boundary based on our constitutional principles, our legal principles, and our customs and traditions. And that boundary really has 3 facets, a kind of who, what, where, about what happens when you cross the boundary from watching people to executing action based on that information. It used to be that when the government wanted to use information that it collected, the who changed. It was no longer exclusively an executive decision to arrest. That decision had to be confirmed by a neutral judge. And the what of that information, the evidence used to decide this person is too dangerous to be allowed free movement, changed in character. No longer was it enough to say, well, mere propensity evidence, suspicion of future dangerousness, which tipped off the government to start watching this person. That wasn't good enough to actually act on that hunch. Something more than propensity evidence had to be provided to that judge. Some concrete information about past wrongdoing, a violation of law. And where those decisions occurred would also change. The decision to come up with a list of the usual suspects, as it were, naturally, that's going to happen in secret. But once we crossed that boundary in the past from watching to action, that list had to be confirmed in a public courtroom by a neutral third-party magistrate. That's a dramatic departure. And I put much of the blame, because I think it's a bad departure, on what happened after 9/11. Now, as to the second question, what stops the United States from using this technique, the old idea of watch lists transformed into the new world of action, to restrict rights besides travel? I say that there's nothing that stops the United States from doing that. Certainly not politics. In June, CNN did a poll that showed that 85% of those polled in the United States were quite comfortable with the idea of a no-fly list. And in fact, quite comfortable with the idea of expanding the no-fly list to other areas like a no-buy list for guns. So there's not going to be legislation, there's not going to be action from the political branches. The only restraint that has been forced onto an unwilling United States government with regard to watch lists has come from litigation, from hapless plaintiffs trapped in these watch lists seeking desperately to get out. And here there will be a happy ending to my story, because in the past that litigation was quite successful in stopping previous attempts to shift from that old border system to a new one of watch lists that are actually blacklists. So let me tell you about an agency you may never have heard of before. This is an agency that was born after 9/11, born because of 9/11, and it's called the Terrorist Screening Center. Before 9/11, we had a no-fly list. It was very, very small. It was operated by the FAA. It was based on a regulatory system called security directives, which excused commercial airlines from their common carrier obligations to carry ticketed passengers. It would protect them, in a sense, from litigation if the captain of that vessel decided that some individual was a danger to civil aviation, which was the language of the security directive. On September 10th, 2001, we had 16 individuals, none of whom were the terrorists who caused 9/11. 16 individuals on a list that was distributed to airline counters around the country by thermal fax paper. Remember thermal fax paper? After 9/11, several public and non-public things happened. In November, the Congress passed the Aviation Transportation Security Act, which shifted from the FAA, that old security directive authority, into a new body that would become the Transportation Security Administration. And they changed the framework. The legal framework was no longer to stop someone who was, quote, a threat to civil aviation. The language now was disjunctive and expanded. A threat to civil aviation or national security. Meaning that somebody could be placed on the new watch lists who was not a threat to civil aviation, but was deemed to be a threat to national security. Well, if all you've got is a hammer, everything looks like a nail. And law enforcement, newly tasked, especially the FBI, took off with this new authority. And the no-fly list that started with 16 individuals rapidly expanded. Today, after a sort of accordion expansion and contraction as we have experienced the last 15 years, we now have about 64,000 people on the no-fly list. And this list is no longer run by thermal fax paper. It's now highly computerized and digitized, and when you buy your airplane tickets, when you make your reservations and provide your name and your gender and your date of birth, you're not providing that to the airlines. That information is going to this new organization, the Terrorist Screening Center and the Transportation Security Administration, who check that information against the watch list. So that's the public face. But the harder to track face of things was the actual creation of this organization. One of the problems that the 9/11 Commission found was that the intelligence community was not sharing information. They were siloing it, protecting it, selfishly keeping it to themselves, sometimes to protect sources and methods, sometimes just to maintain control of that information. And that had to stop, the 9/11 Commission said, and the Bush administration preceded that conclusion several years earlier with a Homeland Security presidential directive that created the Terrorist Screening Center in the FBI. This was to be a multi-agency office funded and administered through the FBI that would gather all that information and create watch lists. One particularly large watch list in particular, the Terrorist Screening Database, and from that mega list, a sort of card catalog, if you will, of all the information we had, create sublists like the no-fly list or the selectee list or a list for visas or a list for law enforcement or a list for customs and border protection, a proliferation of watch lists. So how did it work? And let me now present you with just a few answers to three basic questions. How does the system work? How do they decide who should be on these lists? And who are they, incidentally, deciding who should be on these lists? Well, sometimes the lists worked well, sometimes not so well. You might remember Senator Kennedy. He used to be very popular in town. He was placed on the no-fly list in spring of 2004 and had a devilishly difficult time coming off because this was a name-based list. And T. Kennedy looked similar enough to a suspected IRA terrorist known as T. Kennedy. This T. Kennedy had a personal friend, Director Ridge at the Department of Homeland Security, but it still took him about 6 weeks to get off the list. You might remember Cat Stevens, Moonshadow, Peace Train. Once he became Yusuf Islam, he found himself on the no-fly list. Some people didn't make it onto the list, at least until it was too late. This is a picture of Richard Reed, who in 2001 determined that for the next 15 years you would be taking off your shoes at airports because he is a notorious shoe bomber. He was not on the list because the list is not very good at lone wolf one-off sort of terrorist attacks. And this is from 2009, Farouk Abdul Muttalib, the notorious underwear bomber from the Christmas flight of a Northwest Airlines aircraft, who, despite his father's warnings that he was concerned about his son's wayward behavior, not placed on a watch list. Now, for those who were placed on a watch list, if they complained, and there's no way you can read this letter, aggressive lawyering, a hard-fought media campaign might generate this sort of a letter. And let me just read out to you the operative portion of this letter and tell me if you can tell me what the agency did once the individual complained about a prohibition on travel. If you are familiar with the works of Franz Kafka or George Orwell, this language might be familiar to you. The Transportation Security Administration has received your form and documentation, which you would submit online. In response to your request, we have conducted a review of any applicable records. Were there any applicable records? In consultation with other federal agencies, as appropriate. Was it appropriate? Were there other federal agencies? Where it has been determined that a correction to records is warranted, was it determined? Was it warranted? These records have been modified to address any delay or denial of boarding that you may have experienced. Did you experience any? As a result of the watch list screening process, as opposed to any other process or a list. Now, that was not very helpful information, and it wasn't meant to be helpful, because this list only works if you don't know that you're on it. So how do you get on it? Well, this is a slide, an unclassified version of a slide that was given to me by a former director of the Terrorist Screening Center. He used it to brief Congress, and it explains how the system works. Information comes in about domestic terrorism or international terrorism through the intelligence community and through the FBI, and it's all sent to the Terrorist Screening Center, which creates this enormous terrorist screening database, the TSDB. You can think of this as a card catalog that doesn't contain the actual information, the classified information in these books, but enough information that would lead you to those books. And from that TSDB, the terrorist watch list, the sub-lists are all created. A list for each customer of the Terrorist Screening Center, for the TSA, the no-fly list and the selectee list, for the Department of State, the class list for visa and passport support, for Customs and Border Protection. And there was something very legally useful about splitting up who made the list versus who used the list. Because if you complained to who used the list in a federal court case, you would be told, look, the remedy doesn't lie with us. We just use what we're given. But if you were to complain, if you somehow knew that some other organization, the TSC, created the list, you would be told, well, look, the government, we create lists all the time, but we, the TSC, didn't do anything to you, so your remedy does not reside with us. Well, how do they decide then to put you on one of these lists? Importantly, to put you in the main terrorist screening database from which all other watch lists come. Well, this information came from litigation, hard-fought litigation. This is from an affidavit that was given by a deputy director of the Terrorist Screening Center. And this is the standard, the legal standard for being placed on a watch list. To meet this standard, a nominator, such as the FBI, must rely, and let me just say as an aside, see if you can come up with a reason not to put someone on a list under this standard. Objective, articulable intelligence or other information, meaning that's not objective or articulable, which based on the totality of the circumstances and taken together with rational inferences from those facts, creates a reasonable suspicion that the individual is known or suspected to be or has been knowingly engaged in all of this conduct. Well, the key phrase is here, a reasonable suspicion that the individual is known or suspected. Obviously not beyond a reasonable doubt. That's the standard for criminal conviction. Not clear and convincing evidence, maybe 70% assurance. Not preponderance of the evidence, just an iota over half, just tip the scales. Now, the TSC says this reasonable suspicion standard is more than a hunch, but I challenge you to tell me how it's more than a hunch. In fact, one federal judge said, given that being a suspected terrorist is enough to be placed on a watch list. And given that the standard for being a suspected terrorist is reasonable suspicion, what this standard requires is, quote, a reasonable suspicion of a reasonable suspicion, which sounds like a hunch to me. Well, here is the good news, and then I'll give you the bad news. Litigation has led to the disclosure of that information. Litigation has led to a strong fight against this organization to restrict how they use the watch list, and in particular, to cough up enough information to people who challenge their placement on the watch list that they could reasonably try to challenge the government's decision-making and say, you've got the wrong guy, you've made the wrong inference, you've made a mistake. But it's still devilishly difficult. Here's a Google map of Washington, D.C. We know where the Pentagon is, and we know where the Central Intelligence Agency is, and we know even where the TSA is, they're near Reagan Airport, and where DHS is, they're up near the northern boundary of the district. But it was very hard to figure out that the terrorist screening center was in Vienna. In fact, it only became known, and here is a Google shot of the building, because of a zoning complaint. You see, at the top of the building were all these air conditioners that were cooling the massive databases that were housing all this information. And they were whirring nonstop, 24/7, 365 days a year. And some of the good people in Vienna made a complaint to the local zoning board about the noise in this unmarked, unknown building, which was then forcibly revealed to be the terrorist screening center. Not exactly a welcoming invitation to public access. And there's one more thing about this picture that you should know. It might be a little hard to see, but towards the lower left corner, you'll see a sort of sculpture there. That sculpture is a remnant of the World Trade Center, one of the distinctive but charred pieces of the building that came down that awful day. And inside the building are other artifacts. And it's there for a reason. Because the civil servants who work there, who are all hardworking, well-meaning, dedicated, and well-trained individuals, walk past that sculpture every day. It's meant to remind them what they're supposed to stop. And that, I suppose, is all to the good. But it removes, in fact, it in no way is supposed to support a core structural protection for your liberties. Because in this country, we've always said that it's never enough for one government actor to have the beginning and ending decision about restricting your rights. We've always divided that up. That's what the watch list, action list divide, that border of who, what, and where, was meant to ensure. One person makes a decision and another person detached from that decision-making confirms it. These well-meaning civil servants walk past those ruins every day. And the bias, which is not to mean and not to suggest a malign intent, but the natural bias that can emerge is inevitable. What possible reason would there be in a close call to err on the side of not putting someone on a watch list? As the director of the TSC at one point said, the problem I've got is that if I let somebody onto an airplane and something happens to that plane, what do I say to the victims' families? Or to put it into words of Captain Renault from Casablanca, given the importance of the case, I'm rounding up twice the number of usual suspects. Now let me give you the bad news. This system was never designed with United States persons, U.S. citizens, lawful resident aliens, in mind. Of course there would be some, we thought, but back in 2001, our thinking was that this is an external problem. And so this slide from the Terrorist Screening Center, if you could read the captions under each of these pictures, talks about them. These watch lists are supposed to identify them overseas, stop them before they get to the U.S., stop them at our borders, and encounter them in the United States. But as has always been the case with restricting civil liberties in the United States, we start with them, and we inevitably move to us. It's very much what Jen said before. These systems tend to grow and take root. And so I'll leave you with the last and I think most disturbing slide from the director's presentation. And this was a presentation just before Abdul Muttalib, the underwear bomber, struck that Christmas flight for Northwest Airlines. So a 2009 slide. This was meant to show Congress all the wonderful utility of this card catalog, the terrorist screening database. You see, we could use it for airlines. We could use it for passports. We could use it for controlling hazmat licenses, because if someone's too dangerous to fly, why in the world would you give them a license to carry a truck full of hazardous materials? We can control firearms, a debate that has flared up in the wake of consistent catastrophes having to do with guns and crazed individuals. Passports, law enforcement. Now when you're stopped by the police, they all have computers in their cars, and they all have access to the terrorist screening center. Special events, port workers. These watch lists are not just coming, they're already here. And it's inevitable that in the wake of the next awful terrorist attack, and one will come, there will be a push to use these watch lists again in more expanded form. And if we lose track of that structural protection, that a watch list should not become an action list without some third-party intermediary, then the rights that you hold dear, I think, have been dramatically diminished. Well, thank you, Laura.
Thank you, Jeffrey. So one of the things that strikes me, and I guess in my role as, I'll play very easily the devil's advocate of the person who doesn't really know too much about this level of detail that you've provided today. But I'm struck by the sort of blunt object of technology and surveillance that you've described, and I guess I wonder, there's also been an allusion to the fact that there used to be bipartisan support for some of the issues around terrorism and civil liberties, and that's been degraded over the last 10 years or so. But, you've all touched on this, but I'd like to get back, to the idea of why does it matter, what our country does. I mean, there's symbolism and there's a constitution, but, why is this important that we're dealing with this badly, that we've moved across lines, that our FBI is not always following the letter of the law? And to what extent does Congress understand these issues at the level that you've described them here today?
I can start off. So I think when it comes down to it, it's very important for the U.S. to be a leader on these issues, because especially when it comes to technology, we as a nation hold a very unique role in the world today as really one of the leading innovators. And so there is an opportunity for us to sort of democratize the civil liberties that we are supposed to be enjoying here to nations where citizens are more repressed by their governments. And I think that we're shirking that responsibility in that we've sort of, I think that post 9/11, there has been this sort of collect it all attitude. In fact, that's a phrase that we saw intelligence community leadership use in one of the slides that was leaked during the Snowden disclosures, this collect it all attitude. You certainly see that in the case of internet surveillance. You see that in the case of the terrorist watch list programs. And to a certain extent, you even see that in a very physical, kinetic sense, the way that Jen was describing Guantanamo Bay and how it was first approached and populated, and the threats that we may face if we choose to send people back. And that's there's always going to be this incentive to overreach, right? The whole purpose of democracy is that you've got people amassing power that we give it democratically. That's the government, and they're going to use it to the greatest extent. And we as voters and Congress and the courts are meant to present a check against abuses of that power. And so I actually really agree with Jeff when he says, like, the people who work in all of these agencies are good people, they're well-meaning, and they're trying to do the best that they can to achieve a goal that we all support, right? Keeping our nation secure. I think the problem is that government has insulated itself in a way where it's no longer operating in the transparent way that's necessary for our democracy to function at the highest level. And what I mean by that is you do have members of Congress who are denied access to classified information, even though they're cleared to view classified information when they're attempting to conduct oversight of surveillance programs and other national security programs. You have the government failing to notify the public about really unexpected interpretations of laws. And then we are going to go to the polls in 3 weeks and vote for people who are either advocating for the continuation of those policies and programs or to restrict them. And I think that that's hugely problematic. So in the sense that we aren't doing the best job that we can to protect privacy and civil liberties, I think the number one starting point is to really think about the way that our government is communicating with us about what it's doing, because sort of the thread that ties all three of our remarks together is the fact that there's not a tremendous amount of transparency around these government programs, not around their effectiveness, not around their functionality, and certainly not around the implications that they have for Americans and non-U.S. persons' privacy and civil liberties.
So I mean, obviously, America wields an enormous amount of power in the world, and America's looked to, and it's mimicked by others, sometimes reaction against what America is doing, and a lot of times looking to America for leadership. And that's a role that we play that we should embrace, and we have a responsibility, and I think a unique opportunity in that role. You mentioned the issue about bipartisanship, and I think you're absolutely right. With respect to Guantanamo and certain types of issues, there is zero bipartisanship right now. Hopefully that will change. That's not true with respect to the surveillance debate. I think that there actually is, there are interesting coalitions that cross party lines with people taking a wide array of views, and it's not a polarized debate, Republican versus Democrat, and I think that's important. And I also want to talk about something that's a little bit more optimistic. We've talked a lot about things that everybody's doing wrong, and I'm just going to return for a second because I feel like I didn't get enough time to talk about this, about the issue of law enforcement access across borders and the unique role that America can play in shaping a system that's a better system. As I said before, foreign governments are increasingly trying to get access to data that happens to be U.S. held. These are foreign governments who might be investigating local citizens for local crime, and they're told they can't make requests directly to U.S.-based providers because the data in the United States are held by the United States. There is an opportunity, and as I said, I think foreign governments are reacting by, among many things, passing mandatory data localization laws or pursuing mandatory data localization laws, which ensures that those foreign governments can get access to that data pursuant to their own standards. In many cases, those standards are a lot lower than the standard that would apply if they have to make a request to the United States and get a warrant based on probable cause. The Department of Justice is increasingly concerned about this for a wide array of reasons, and they've recently proposed legislation that would begin to address this. This legislation would allow the executive branch to make agreements with foreign governments. If those foreign governments meet a whole range of criteria, they have to respect the rule of law, they have to be privacy respecting in how they treat data. And if those agreements are put into place, that foreign government would be able to make direct requests to U.S. companies, bypass the onerous diplomatic channels, as long as those requests met a number of criteria. They have to be particularized, they have to be lawful, they have to be reviewed by a court. Those requests would be permitted only for non-citizens that are outside the United States. If the foreign government wanted to get access to U.S. citizens' data or to data of persons that are in the United States, they still have to make a diplomatic request and get a warrant based on probable cause. That makes normative sense. The U.S. government has a role in setting the standards for access to data of people in our country and U.S. citizens' legal permanent residents. It doesn't really have so much justification in telling foreign governments what standards should apply when they access their own citizens' data that are located outside the United States. But what's special, what's unique about this opportunity is because the U.S. is setting the standards and telling the foreign governments what rules have to apply, it's an opportunity to kind of level up, to set a playing field that might be slightly higher than what would apply if the foreign governments were just accessing the data pursuant to their own laws. Here the U.S. has an opportunity to say, here's some minimal baseline standards that ought to apply when foreign governments are making cross-border requests for data. If you meet these standards, foreign governments, you can have expedited access. You don't have to go through this onerous process. And it's, I think, a real unique opportunity and a time-limited window for the U.S. to act and take advantage of this. before the world kind of balkanizes. So I just wanted to present something, an optimistic note amidst a lot of not so optimistic discussions here.
Well, here's some more doom and gloom. If this world's self-proclaimed last remaining superpower, a nuclear-armed superpower, needs a terrorist watch list and professes to need a terrorist watch list to protect its borders, and not just its external borders, but its internal movement of its citizens, you can bet that that sends a signal to a lot of other countries. Some of these countries are our allies. The Five Eyes all have variations on these watch lists, but there are a lot of countries where watch listing actually is not such a new concept, and actually action lists are not such a new concept, and this just green lights that process even further. It stamps it with a seal of approval, if you will, that the world's leader thinks that this is a reasonable approach to treating its citizens and visitors. There's a second problem, though, and that is that we're also signaling something else, something much more serious. In every one of the major cases that have been brought against these terrorist watch lists, and I have started a website called watchlistlaw.com, where I am tracking all of these cases and providing the opinions and briefs and arguments so that they are accessible to the public. In every one of these major cases, the plaintiffs, and I preface this by saying that a complaint is merely a set of allegations unproven, but these plaintiffs have consistently all pointed to the same MO. They are stopped in some foreign country or at home, taken to one side, told almost invariably by an FBI agent, if you'll help us, I can get you off this list. And the help that is wanted is to become an informant in your community. And so these watch lists are now not just being used to protect civil aviation, not just being used to prevent someone who's a threat to national security from getting on a plane, but now being used to present someone who, at least from the allegations of these complaints, appears to present no threat at all, but has information that the government would like to obtain, can't seem to obtain singularly or completely from the resources that Jen and Robin described, and so now wants to use human intelligence. Human, the greatest intelligence of all. That's what so much of our spycraft was based on in the past, and now the watch lists are being converted into a new kind of tool. And if those allegations are proven, and the variety of plaintiffs and reputable law firms who have made these allegations lends credence to thinking that we ought to get to the bottom of it, then it's a very dangerous development, not just for us, but for other countries.
I'm going to ask one more question and then turn it over to the audience for questions. But a few of you have referenced the public. And I think, Jeffrey, you used statistics. 85% of the public like the no-fly list, like the no-buy list. And obviously the public and Congress are supposed to be related to each other. But what do we do about the public and its role in all of this? Because to an extent, people are not concerned, maybe because they think they're not doing anything wrong, and just maybe the bad guys are going to be watched. I mean, to what extent is that playing into all of what you're talking about here today?
So, I think, I specialize in privacy issues, right? So how does the public think about their privacy? How does the government treat individual privacy? And there seems to be this sort of myth that people don't care about privacy anymore, right? We all post to Facebook, we tweet, we do all sorts of stuff on Instagram and Snapchat and apps that I don't even know what they do. And so we obviously have sort of given up our right to privacy, right? But that's a myth, because when you actually ask people, what do you think about your privacy? They say it's really important. Pew conducted a study about a year ago, and they found unequivocally that Americans in particular who are interacting online, who are using apps and Google searches and things like that, are actually attempting but having a very hard time figuring out what kinds of information about themselves they're giving up. and are making attempts to either anonymize themselves online or at least to use their privacy settings in a way where they can better control the information that they share. And so that's sort of, I think, where we need to do a better job of defining what is privacy, because in the context of national security, privacy has been dubbed essentially as secrecy, right? Not government secrecy, individual secrecy. But in reality, privacy has very little to do with secrecy, and in fact has everything to do with liberty and autonomy. It's having the autonomy to choose what information you share, with whom you share it, and when you share it. And the problem that we have right now is that government in particular, and companies as well, but that's sort of a totally different, basket of apples. But government in particular has engaged in a sort of new wave of mass surveillance where they tap into the backbone of the internet and copy all of the internet that goes across it, and then search that data for keywords, for selectors. This is called upstream surveillance under Section 702. They send those selectors to companies and have companies scan all of their information, all of your information, to see if anything is responsive to these inquiries, and then send it back to the government. That's PRISM under Section 702. And there's a ton of other types of information gathering and information sharing relationships with other countries, some of which have to do with some of the cross-border data request issues. And really, when it comes down to it, nobody has a clear idea of what these programs are doing, and that's by design. Everything is classified. Everything now is a source and method, and so we as the public, even though we really do care about our privacy, A, have trouble articulating that, but B, have trouble really understanding how it's being implicated by the government. Because by and large, most people don't feel the impact of government surveillance, but there are millions of people on the terrorist watch list. I think there was a story in the news 1 or 2 years ago that there's some 1.2 million people on like a Tide watch list. I could be misremembering, but this is a problem that affects more people than we realize. And so it is the kind of thing where I think we need to start thinking about this more in terms of what is the government telling us, and why is it not telling us things? Because we're not getting information on efficacy. We're not getting information on the scope of surveillance that's going on. We're not getting information on how that surveillance is being used, whether it's not just being used in national security investigations, for example, but is instead being sent to the FBI or the DEA or other law enforcement agencies for other types of criminal investigations. And so this is the kind of thing where the public, in a sense, because of excessive secrecy, has had its power taken away from it. And that in itself damages privacy.
So I think the question about the public debate's a really, really interesting and important one. And I think to some extent, the public debate, I think, reflects the complexity. And we've all come here with a particular perspective. But all of the issues that we've talked about raise important questions about security, privacy, liberty. And to some extent, I think it's misleading to not suggest that there's some trade-offs and some choices to be made. And I also think that all of the issues, we spend all of our time focusing on these issues, and we each know a little piece about each little issue. So you can't expect the public to have the same level of debate. That's just not realistic. People have jobs, they have lives. They can't. There's no. Even if you wanted to, you couldn't inform yourself in a way that's sufficiently sophisticated to really have a nuanced debate about a lot of these issues. But I think there's a bigger problem, and that's about how people get information. So as a society, we're increasingly getting information in our little silos. So we all talk to people. We all get this. Our social media feeds are all people who agree with us. And that's true for everybody. And so I think I don't know how to solve this, but I think there's a real dearth of meaningful dialogue across different ideological groups, across different political groups. And I think that really hampers the public debate and the public discussion on all of these issues, because these are hard issues.
Well, I think my friends of the Justice Department would say that the congruity between these public opinion polls and the lack of legislation just shows that the political process is working just fine. Thank you very much. That's representative democracy. But I think that because so many of these watch lists tend to pick on discrete and insular groups in our society, and because by definition, once you've been watch listed, you now are bearing a label that you tend not only not to want to wear about in public, but instantly discredits you. You are under suspicion, and therefore a source that is not going to be listened to with the same degree of concern. I think there's some hope with these lawsuits, which are proliferating, just as the watch lists have proliferated, and that might be a way, since I think the system is unbalanced, to rebalance the system. Because state and local governments are beginning to use watch lists too. The state of New Jersey has a connection to the federal watch list for all gun purchases in that state. And other state and local law enforcement, which has the most interaction with the public, are beginning to use these lists. Well, those actors, although well-meaning, are not quite as sophisticated in their use as federal enforcement and the federal offices that develop these lists. And so they're generating more problems, more publicity, more concern. I'm just reminded, especially seeing his picture as I came in here today, when Zbigniew Brzezinski came to my home institution to give a talk, the last question he was asked was, what keeps you awake at night about national security? And without batting an eye, he instantly responded, the level of education of the American voter. And so I think that these lawsuits have an educating function. They reach down into communities. They tend to get a lot of play in local editorial boards and local newspapers. And if the watch list proliferate, as I think they will, then maybe the answer is a grassroots response.
Yeah, and I just wanted to add one thing. I mean, despite my skepticism about some of the public debate, I really do want to echo something Robin said earlier, which is the importance of transparency, particularly in two areas. One, of legal opinions. There is absolutely no justification in not providing the legal justification for a particular policy. There's all kinds of specific facts, sources, methods that do need to be kept secret, and there's good justifications for keeping them secret in certain circumstances, but there is no reason not to publish the legal justification. And the USA Freedom Act that Robin also talked about requires the Foreign Intelligence Surveillance Court to do so going forward in any major opinion that's of particular significance. That obligation should also be applied retroactively, I think, and it would cover the Yahoo case that Robin talked about as well. And this also goes to the no-fly list. Regardless of how one thinks about the no-fly list, it makes absolutely no sense for the government to refuse to disclose to somebody who's gone to the airport with the ticket in hand and told they can't get on a plane, the fact that they're on the no-fly list, which the government used to not even tell individuals that, and also the basis, some minimal information about why they're on the list. As the result of the lawsuits that Jeff talked about, individuals can, if they file a suit within a certain amount of time, get some of that information, but I'm not sure that it's sufficient to really meaningfully challenge that, and I think that's critical as well.
I would just add, litigation is absolutely a good way to get more information. I mean, I did mention that one of the only ways a court ever hears about, for example, a national security letter being issued is if the recipient goes to the court to challenge its legitimacy. But that's also hugely problematic because that means that if you are depending only on litigation to right wrongs that government may do, then you are depending upon people who, as Jeff pointed out, for many reasons are disincentivized to bring to light the fact that, they have been put under suspicion in some way by the government. But you're also depending on the fact that people have the time and the resources to do this, or that they will be able to associate themselves with organizations who can represent them and litigate on their behalf. And the truth is, we don't have the resources that we need within those organizations or the individuals to be able to support that. And then that's not even getting to the other problem, which is a lot of times some of these challenges do wind up getting actually litigated right on the merits. But oftentimes, especially in the context of government surveillance, the courts never wind up ruling on the merits of a case. The ACLU recently litigated a case on behalf of Amnesty International against DNI Clapper about Section 702 surveillance. And in the end, the court said, Amnesty, I'm sorry, you don't have standing to challenge this law because you can't prove harm. Because this was secret surveillance, you can't show that you were a target of the surveillance, that your information had been collected under the law, even though we now know that it almost certainly was, thanks to the Snowden disclosures. But the court wound up throwing out the case just a few months before the Snowden disclosures began. Since then, additional cases have been filed, but then, even if you do get past the standing issue, there are problems with regard to government secrecy, where the government may be able to claim that they can't disclose information that would be necessary for the court to decide on the case because they get a certain exception for national security. And at the end of the day, I do think that we need to start thinking about this in addition to as something that can be resolved in the courts, as something that we really need Congress to focus on mandating more transparency and the public to start demanding transparency. Because it's not just our rights, it's our tax dollars too, right? Like, this is one of the things that is a huge topic of the debate, our budget deficit. Well, billions of dollars go into the surveillance apparatus every single year. And so at the end of the day, we not only have our rights, but we have a personal investment, each of us, in these programs. We should make sure that they are respecting our rights and that they're actually effective.
Litigation and education, which is just the sort of answer you'd probably expect from a law professor.
Yes, so questions? Will, do you want to start?
Sure.
Yeah.
I have a broad question, but I'll ask it specifically for Jennifer. You've talked about the attempts to globalize the issue. To what extent is this really require a global response in terms of addressing kind of how one approaches different governments and standards of evidence and so forth? Or if the world develops simply domestic solutions all around the world, is this just going to become too complicated to really be resolved?
Right, so it's a great question with respect to cross-border data flows. In an ideal world, we would have some sort of global treaty and everybody would commit to baseline substantive and procedural standards in terms of how they got evidence, and there would be some sort of supranational warrant, and some special supranational judge would issue that warrant based on standards we all agreed on. That's not the world we live in, unfortunately. And so from a more realistic perspective, I think the way to begin to build out these kinds of norms is to start small and to start with bilateral agreements, maybe with small multilateral agreements. But if we try to come up with a global solution at this point in time, I think you're going to end up at the lowest common denominator, and it would be a bad result for everybody.
And I have an even broader question. Assume for a moment that there is a value in surveillance and some kind of lists. I don't know whether there is or not, but let's assume for the moment there is. How would you say we could do it the right way with American principles of civil liberties and rule of law? How do you do it? How do we set the example for the world and do it the right way?
Well, I could say briefly my view on these lists, although I dispute the premise that these lists are viable in our constitutional democracy, but assuming that I'm wrong on that, I'd say at the very minimum, you need to inject not just a third-party neutral magistrate to make these determinations and restore us to what watch lists actually used to be, the old historic border. So that means notice and a meaningful chance for someone to be heard. But the other thing that you'd need is a congressional restriction on that civil aviation or national security tag, because it's too broad. If the concern is protecting civil aviation, which has always been a valid concern, it's been a concern since, magnetometers came to light in the 70s, and bombings and hijackings started in the 60s, so this is an old problem and an important concern. Well, then limit the no-fly list to flying. And that in itself would reduce a lot of the concerns about coercion, about expansion, about pressure, and force the list to conform to what its title says it does.
So I'm skeptical that you would ever be in a situation where magistrates would be in an ex-ante position of reviewing these lists. But what I do think is critical is once somebody has suffered a deprivation of liberty, once somebody showed up at an airport with a ticket in hand and told they can't fly, and travel is a protected right, there needs to be meaningful post hoc review. At that point, the individual needs to be told enough sufficient information to meaningfully be able to challenge it. And there should also be time limits on how long somebody could be deprived of their liberty in that kind of way without the initiation of criminal charges or other sanctions that do have many more protections and oversight associated with them. I do think that there is a role for some preventive restraints that are administered by the executive branch, but there has to be post hoc review, and there have to be limits, particularly on duration, in my view.
Oh, I didn't mean to misspeak. It doesn't necessarily have to be ex ante. It could be ex post. But the concerns that Jen has identified are exactly my own.
So, and I actually think with regards to surveillance, the same type of limitation would be really important. Right now, you know, we have way too many people who are being swept up in surveillance programs. And so there's obviously a targeting issue there, right? We should have more particularity with regard to whose communications that we can collect. There also needs to be more specificity with regard to how that information can be used once it's collected. But in addition to that, I think one of the bigger problems is people never find out when they have been the subject of surveillance, especially in the context of national security investigations. Unless there's a prosecution, people just won't find out, especially when it's sort of these lower level surveillance tactics like NSLs, which, as I've described, can reveal a lot of information about a person. People almost uniformly never find out that they were the subject of an NSL. And so I do think that providing adequate notice and an opportunity for redress is one of the more essential steps to reforming our surveillance system.
Can I add one more thing? On the surveillance point, I think one issue that Robin's alluded to before, but the 702 program, the program that governs the collection of communications where the target is a non-U.S. person and the collection takes place in the United States. Pretty broad collection, regulated by the Foreign Intelligence Surveillance Court, but yields large quantities of data. And one, again, with respect to, my concern is more with post hoc, the use post hoc after collection. As 702 is set to expire in December of 2017, there's going to be a debate in Congress about what to do about it. I think most people think it will be renewed in some form. It's a program that the intelligence community says is incredibly valuable and has been quite useful. One reform that I think is really important to think about when considering renewal is how the data, particularly the data of U.S. persons, U.S. citizens, U.S. residents, people in the United States, is used once it's collected, and particularly used by the FBI. And right now there's very little limits in terms of how the FBI can search these databases that have been collected for foreign intelligence purposes. And I think it's important to place some limits. I wouldn't go quite so far as to say that every case has to be reviewed by a judge, because I don't think that's right, but at least some standards, additional standards governing FBI use and review of these databases.
And it's just kind of important to realize, if you're not very familiar with the laws, criminal standards for collecting this kind of information are much higher, right? There's generally a probable cause standard for accessing this information if you need a warrant to get it. When you're collecting the contents of people's communications under the Foreign Intelligence Surveillance laws, the standard for collection is significantly lower, and the amount of judicial oversight that occurs is also significantly lower. For 702, for example, the FISC judge, the FISA court judge, issues an order for programmatic surveillance. So it's not looking at each target and saying, yep, there's a reasonable basis for collecting this person's information under the authority. They're looking at the general parameters of the authority and saying, yep, this meets with the requirements of the law, you can go ahead and continue this program. And then once the government gets this information, as Jen was saying, they look through these databases for criminal purposes, for totally non-national security and non-counterintelligence investigations.
Well, this has been a fascinating panel. Unfortunately, we're out of time, but I think that the panel's discussion and the questions have grounded us for the next discussion, because not only is the U.S. doing whatever job it's doing here at home, it's going to make a huge impact on what the rest of the world is doing, and since the world looks to us for setting the standard. And so we'll be talking about that now on the next panel. We will have a break for about 15 minutes. But I'd like to thank Jeffrey Kahn, Robin Green, and Jennifer Daskell for really educating us today in such an informative way. So thank you.
Thank you.
Thank you.